testimony, I would like to talk about both bills before the committee today, and both of them would change the state statutes defining who could use the absentee ballot procedure to conform the language to the language in the state constitution. So in other words, the statute would be changed, not the state constitution. The Constitution currently allows voters access to absentee ballots because of, quote, absence from the city or town of which they're inhabitants, and, quote, because of sickness. These bills would simply put that constitutional language in statute, and it would mirror it exactly. Although this change in language would make it somewhat easier for a voter to vote by absentee ballot, and I support this proposal, it does not allow universal access to absentee ballots without requiring the voter to provide an excuse. But it is an important and reasonable step to take while the constitutional amendment to allow all voters to access a vote by absentee ballot if they choose to do so is waiting for a second approval by the legislature in 2023 or 2024, and ultimately by the voters on the ballot in 2024. Senate Bill 184 would also extend temporary changes to the absentee ballot statutes made by the legislature in the last 2 years through the 2022 election. The legislature made these changes for the election in November 2020 because of the COVID-19 crisis, which necessitated allowing Connecticut voters to vote by absentee ballots if they chose to do so. The Connecticut Supreme Court decided in August of 2020, with an opinion issued in February of 2021, that this measure is constitutional, holding that sickness in Article 6 and Section 7 of the Connecticut Constitution is not limited to an individual voter's illness, and it's broad enough to include a specific disease like COVID-19. The legislature then extended those changes at the height of the COVID-19 Delta variant. Of course, since that time, another variant, Omicron, has spread across the world and appears to now be receding. The COVID-19 pandemic is ongoing, and we simply don't know when another variant will emerge, how fast it will spread, how severe it will be, or when it will peak. Voters voting in this fall's elections should be allowed to choose to vote by absentee ballot if they desire, and should not be forced to make a choice between their health and their right to vote, as we have been saying all along. Every voter and group that I speak to makes the same request. Let us choose to protect our health and vote by absentee ballot in 2022, as we did in 2020. Allowing voters to be able to request an absentee ballot using COVID-19 as an excuse would be a welcome change as the COVID-19 panic continues and new variants emerge. So I support both these common sense, voter-centric bills. And with that, I am open for questions. Thank you.
Thank you, Madam Secretary. Any questions or comments? Senator Sampson, your hand is raised. The floor is yours.
Thank you, Mr. Chairman. That always takes me off guard because my hand's actually not raised. It's, but I do recall that we have these icons in the corner to note when we want to speak. Good morning, Madam Secretary. Delighted to see you as we get the pleasure of your presence in our committee once in a while. So thank you for being here today. I want to. I have a few questions, and before I start, I just want to make sure that I do want to circle back to your final comment because I'm in agreement with you on the subject that people do deserve to make choices about when they should be allowed to vote and how. And this, my line of questioning might lead some people to believe otherwise, but I am very, very strongly in favor of providing as much access to voting as possible. But I am equally concerned about making sure that we protect the integrity of elections. And to me, that's the focus of my questioning. I guess the first thing I want to ask you is, were you the source of these two proposed bills? I know that this is very similar to the legislation from 2020, or not legislation, the executive orders in 2020 that ultimately allowed for COVID voting, for lack of a better term.
Yes, we were. The language mirrors the language we proposed last year. So in that sense, yes, it is our proposal.
All right, thank you. Since that's the case, you mentioned COVID quite a few times in your opening remarks. I didn't actually get to see your testimony. I'm sorry. I was looking for it last night and I didn't see it online, but I'm sure it's there now. Is this language that's before us primarily because of COVID or for other reasons? Through you, Mr. Chairman.
Well, at the time through you, Mr. Chairman, when we originally proposed it, of course, it was certainly in response to the COVID situation. But we also recognized that the language in the Constitution was pretty broad. And so we just, we asked to have that implemented, basically. But it is, since then, has been interpreted by the Supreme Court as being broad enough to include other forms of public health emergencies, if you will. So I think our sense was that this decision, certainly in the case of 2020, should be in the hands of the voter to decide, because ultimately all these questions of absentee ballots, the question rests with the voter as to how they interpret. Are they going to be out of town on election day? Do they have illness in mind? Is there something that's preventing them to get to the polls? So ultimately it is their choice to determine that. Of course, they have to go before the town clerk and sign something saying, yes, this is my decision that I feel that I meet these tests.
Well, I appreciate that answer very much. I don't know that I agree with it. I don't think that the definition in the Constitution is broad, and we will certainly touch on that in a moment. Mm-hmm. And I would also say that it's not entirely up to the voter. I mean, we do have laws. We have a constitutional requirement. We do have a statute. I can't decide whether or not I'm going to obey the speed limit or stop signs. I mean, it's not really up to individuals to make a determination. They have to fall within the guidelines of the law. But I guess since we are focused on COVID, is it your impression that the public health emergency is continuing? I mean, is there a public health emergency right now? And more importantly, do you believe that there's a public health emergency that will occur in November that we should be making a change now for? Through you, Mr. Chairman.
Yes, through you, Mr. Chair. Well, I guess I'd say I'm not an epidemiologist. I have no idea. And I think it's the $64,000 question, isn't it? Everybody's been struggling with this question. But whether or not there's an ongoing public health emergency, it would certainly behoove us to prepare for that eventuality, I would say, because we really need quite a bit of notice if the legislature is going to act to change this interpretation again for the purposes of the 2022 election. There's quite a bit that goes into it ahead of time. So I would just suggest, this is a decision that has to be made by the legislative body as to whether they want to extend this situation to the 2022 election. But I'm glad we're talking about it now. And of course, we're going to try to speculate, but none of us know really where we're going to be in November.
Thank you for that answer. And through you, Mr. Chairman. So I hear what you're saying, and certainly nobody knows what November is going to bring, which is why it kind of bugs me a little bit that we're talking about COVID as a purpose for modifying the Constitution. I would also say that, the last time we did this, it was done by executive order. It did happen relatively quickly, even ahead of the July primary in 2020. And if it's a matter of simply redefining a statute that to conform to the Constitution to change the eligibility requirements, I don't think that requires any time frame at all. That's just a change in the law and the change in people's understanding of it. What might take preparation is if there is some additional changes, like a mass mailing of ballot applications, which is my great concern, and I believe the ultimate purpose of this legislation. So I guess let me ask this question. So this change is not just for this November. If these bills, one of them is adopted or both of them, that would mean that we're going to have these changes effectively going forward permanently. Is that correct through you, Mr. Chairman?
Yes, through you, Mr. Chair. The change is permanent in the sense that we are at the first part of it in particular, where we're changing the statute. We're simply conforming the language of the statute to the Constitution. It's important to remember that. We're not really making a change. We're changing the wording in the statute to mirror the language that's in the Constitution. And so that would make it, it gives it more clarity in terms of when a court goes to determine it, or where we have a case before us, we can make a better determination of, what the interpretation would be. But in that sense, yes, this is a permanent change to the statute, not to the eligibility in the Constitution.
Thank you for that answer. And thank you again, through you, Mr. Chairman. I do want to go back and debate that subject with you, and I plan on getting there because, we had this legislation last year, and I offered an amendment to change this language, which I think is identical or very close to what was proposed last year, with the actual sentence from Article 6 of the Constitution, and it was rejected. So we're going to come back to that, but I think we should reconsider saying that we're simply conforming, because I don't think that's accurate, and I think that'll be clear by the end of this conversation. But before I get there, I really want to get to this situation. Let me ask some basic questions first off. First thing is this, and I will point out that the Senate, the United States Senate yesterday actually passed a resolution ending the state of emergency nationally. So again, predicting November is to me a complete mystery, and I don't understand this bill because of it. But I'll try not to editorialize too much. Madam Secretary, through you, Mr. Chairman, what does it cost to mail all of the ballot applications to the people on the voter rolls in the state of Connecticut? And also, what does it cost to mail the ballots as well? And maybe you can give me a little detail, like, what does it cost in a primary and what does it cost in a general election? Through you, Mr. Chairman.
Through you, Mr. Chairman. Well, first of all, we did that mass mailing of applications as a one-time thing with federal money in 2020. We have no resources or intention of doing it again because it doesn't seem warranted. So normally applications are obtained by a voter themselves from our website or from their town clerk or registrars of voters. And so I don't have any way of knowing what the total cost would be. I don't have with me the number that it cost us. It was a federal grant that we used to mail the applications. I could call on, if you want a specific answer to that question, I do have Attorney Ted Bromley, I think, is on the line. Maybe he recalls what the approximate cost was for mailing those applications as a one-time cost. We do not mail ballots, so every town would mail the ballots out, and I have no way of knowing how much that costs statewide. So Attorney Bromley, do you want to quickly come on and see if we can recall what that rough number was for mailing the absentee ballots statewide, the ballot applications, that is? I know there's always confusion about that.
He's present. I'm not sure if he's.
Yes, I'm here. Can you hear me, Mr. Chairman?
Yes, sir.
Okay.
You're fine.
Okay, great. Yes, hi, I'm Ted Bromley. I am Director of the Elections Division for the Office of the Secretary of the State, here with Secretary Merrill. So in 2020, when we did do the project for the statewide absentee ballot application mailing, the total price tag for that mailing was approximately $1.5 million.
Thank you, Attorney Bromley.
You're welcome.
Senator Sampson, I believe the floor is still yours.
Thank you, Mr. Chairman. And I appreciate that answer. I've seen it widely reported that the elections cost $7 million. I got to assume that you're mailing out at least somewhere between 1 and 2 million ballot applications, and then A number of those obviously would be returned, and a request would be made for ballots. And we did that in both July and in November. It doesn't seem to me like $1.5 million would cover that. Maybe a little more digging, and hopefully we can get a more accurate number going forward. But I don't want to waste the time of the committee. Suffice it to say, it's millions of dollars to send those ballot applications. And I appreciate, Madam Secretary, you saying that you have no intentions of doing the mass mailing again. That brings up a couple of other concerns, because for one thing, in 2020, we did this because there was the COVID pandemic afoot, apparently. But in 2021, there was no mass mailing by the state government, although there were some towns that chose to do so. And there were quite a few political candidates and party officials that chose to do also. And I just will express my concern with that, which is that if we are going to leave it in the hands of the average person to send out ballot applications once making everyone in the state eligible, versus the current system where you have to be eligible by very narrow circumstances, you are essentially creating a situation where the Democrat candidates and party machinery would be targeting their voters and mailing their prospective voters that are going to support their candidate. And the Republicans will do the same. They will target their voters and they will send them to people that they think will vote Republican. My concern about that is that what about everybody else who's not a targeted voter? They are going to be left out of that. It doesn't seem like a very just thing to do. And in fact, even less just than mailing out the ballot applications to everyone. But when you say you have no intention of mass mailing again, does that mean you will absolutely not do it in November? Or does that mean that you expect that the towns will? Through you, Mr. Chairman.
Yes, through you, Mr. Chair. Well, first of all, I'd like to respond to some of the things you raised here. First of all, nothing here makes everyone eligible for an absentee ballot. What we're doing is clarifying what that excuse looks like. You still have to have a quote excuse to get an absentee ballot. As far as the applications being mailed, for many years, candidates have always mailed applications out. You have to remember, applications are available to anyone who wants one if they go online and get one, or go to their town clerk and get one. You can fill it out right at the town clerk's office and hand it right in if you're on the voting rolls. So, no, we have no intention, because we have no resources to do a mass mailing. If towns choose to mail to all their voters in their towns, as some towns, as you said, did, I think it's a good thing. It's making it easier for people to vote. If they choose to vote with an absentee ballot, they still have to sign the paper saying why they're using an absentee ballot. We still are a state that requires you to have an excuse to get an absentee ballot. Nothing changes that, because that's in our state constitution. I, for one, wish it weren't like that. I think any voter who chooses to vote by mail or by absentee ballot, or whatever you wish to call it, should be able to do that if that's what they choose to do. If they're on the voter rolls and they're an eligible voter and they're 18 years old and a citizen of the country, they ought to be allowed to vote in whatever way is easiest for them, particularly during a time when it's difficult for people to get to the polls for one reason or another. So I would just say, yes, it is certainly not our intention, because we have no resources to do so. I think it's much more effective if the towns continue to manage absentee ballots and all other election-related expenses and situations that go on, like registering voters. It's all done at the town level.
I appreciate that answer, Madam Secretary, and through you, Mr. Chairman. Again, I don't disagree with you about giving control over to the public to make more decisions and have more access to voting. But that's not what we're debating here. I mean, frankly, we're debating a very specific piece of legislation and an interpretation of the Constitution. On another day, and I would be delighted to have the conversation about no excuse absentee voting or anything like that. because I'm very much in agreement with the fact that we want to provide access to voting. But I can't help but disagree with the characterization that you've made several times now that this is just to conform to the Constitution and that it does not provide universal access. And I was hoping to finish our conversation with that, but let's talk about it since we're going to. The issue really here is whether or not sickness applies to
workers that immigration status could be
Mr. Chairman, can you ask people to mute? Thank you.
Yes, please, if you're not speaking, please put your speakers on mute. Thank you. Oh, the Senator Sampson.
No problem, Mr. Chairman. As I said, through you to Madam Secretary, we've got to narrow down what the Constitution actually says. So I'll read it for the sake of the committee because we're sitting here and this is what we're talking about. We may as well get it out in the open. Article 6, Section 7 says the General Assembly may provide by law for voting in the choice of any officer to be elected or upon any question to be voted on at any election by qualified voters of the state who are unable to appear at the polling place on the day of election. Now we're talking about voters of the state who are unable to appear at the polling place on the day of election because of absence from the city or town of which they are inhabitants, or because of sickness or physical disability, or because the tenets of their religion forbid secular activity. And I understand the argument that's being made in this bill and the one that's been made continuously, which is that sickness doesn't say your sickness. But I would argue that none of these items say your in front of them, but it is implied that this it applies to a singular voter because the other items absolutely do. You certainly would not ask for an absentee ballot because your neighbor is absent from the city or town which they are inhabitants of, or because your neighbor is physically disabled, yet it doesn't say your physical disability. So this is the debate we're going to have on this subject is what it actually means. And I can understand that there was a court case, but I don't think that's the end all be all. The fact is that this the state of Connecticut has been operating as if sickness means a personal sickness since the Constitution contained this language. The statute was written to conform to that understanding, and we're just now trying to change it for some other purpose. And the purpose is what concerns me, which is the eligibility becomes everyone. And so let me ask you this question. So let's go back to this. So what about physical disability? The bills that are proposed before us both take out such persons ahead of physical disability, which would essentially enable someone, if this bill passes, to get a absentee ballot because some other person is physically disabled. What's your response to that through you, Mr. Chairman?
Through you, Mr. Chairman. I can only repeat what the court said about this issue, and I will quote from what they said. They held that sickness in Article 6, Section 7 of the Connecticut Constitution is not limited to an individual voter's illness, broad enough to include a specific disease like COVID-19, not just COVID-19, you note. So I can only say that I agree with their interpretation that just saying illness or sickness doesn't mean that that individual person has to have the illness or sickness. And that is what the holding of the court was. And that's, I'm sure, what people will go back to if a case comes up to challenge this. And it also says physical inability to get to the polling place is not a necessary requirement for rendering a voter unable to appear. And that's the heart of the matter. If you're unable, the whole situation is, are you unable to appear? And when you talk about whether it's due to physical disability or sickness or whatever it is, the voter is the one who determines if they're unable to appear. And they have to swear to that. And so I don't know how much further we should go in trying to restrict people from getting absentee ballots. It's clear that we still have a restriction. I wish we didn't, because I think it should be the voter's decision as to whether they want to use an absentee ballot. But this is how far the courts have gone at this point. And I have to say, I do agree with their interpretation. That's all I can say.
Well, thank you for that answer, Madam Secretary. And through you, Mr. Chairman, I appreciate the court's interpretation, and I've read it also. I think it's erroneous, but it's also not relevant today, because what we are discussing today is whether or not we are going to change the relevant statute, which I believe goes back to the Constitution. And I don't believe that court's erroneous interpretation is relevant in the future challenge of this law, if there is one, or whether or not we are to modify this information or modify what the statute says. And by the way, your point is that it's if someone is unable to appear, but yet the statute or the proposed bill before us actually removes the language that says during all hours of voting. Effectively, what you are changing here is you are not only saying that you don't have to be personally ill or personally out of town or personally disabled, but you're saying that you don't even have to be missing during all of the hours of voting. My interpretation of this statute, and I believe the court, if we got the same court to look at it, would agree with me that we've created no excuse absentee voting with this modification. And how do you respond to that? Through Mr. Chairman.
Through you, Mr. Chair. No, we have not done that, because what you're doing is removing the language that says all hours of the polling place was added in the statute. We are free to change that if we think that someone's absence has to be all hours of the election day. And so that still is a restriction. You have to swear that you're going to be absent from the jurisdiction during part of election day. That would make you unable to appear at the polls. That's the main point. You, the voter, decide that you need to use an absentee ballot because you're unable to appear at the polls for those reasons. But those words were added in later. They are not in the state constitution. So they require that actually requires an additional limit on your ability to get an absentee ballot, which I don't think is constitutional necessarily. If the legislature chooses to take that language out, there is no reason that they shouldn't be able to do that if that's the will of the body.
Thank you for that answer, Madam Secretary. And I don't disagree with you that we should be able to make that modification if we want, but by doing it, you are removing the qualifications that require someone to have a reason for obtaining an absentee ballot. The Constitution also says the day of. The statute says during the hours of voting. That is a distinction, and I will grant you that removing it is not as critical a change as redefining what the Constitution says about sickness. So for example, what is meant by sickness? Let me ask that question. If we're simply going to modify things from the way that it has always read, which is such elector's or person's illness, which I believe conforms with the intent of the Constitution, which refers to a specific voter's inability to appear because of sickness. What is it meant when we simply use the word illness? Whose illness are we referring to? Through you, Madam Chairman. Or Mr. Chairman, sorry.
Oh, we had a change there. Yes, through you, Mr. Chair. That's open to the interpretation of the section of the statute, and that will be determined when it comes about. Could be determined in a number of ways. I'm not here to make a determination about any specific case that would come before us, because we'll have to wait and see what comes up as an issue. But essentially, you are all these sections of the statute rely on the voter to come up with the excuse, if you will, and to determine. The voter first has to be the one who says, yes, I am going to be out of the jurisdiction, let's say, for part of the election day, which will make me unable to appear to vote. And so it starts with the voter, and should start with the voter, because they are the ones all along. Always, the voter has had to be the one to step forward and say, I'm not going to be around on election day, or I have an illness, or there is an illness that will prevent me from getting to the polls. That's the main point, is that it has to make you unable to get to the polls. And that clearly is in the hands of the voter to decide if they meet that test.
Thank you, Madam Secretary. I don't disagree with you, but that is the precise problem with this language. in my estimation, which is that if you leave it up to the voter to determine whether or not the word illness is a reason for them to be unable to appear, there is no test. It becomes no excuse absentee voting, which is what I'm trying to illustrate here. In fact, people running for Secretary of State in both parties, and I don't have you on record calling this no excuse absentee voting, although I wouldn't doubt if you did also. Everyone knows that the 2020 election was a no excuse absentee voting election that was never intended. When you say, when you remove such electors or persons before the word illness, now you just have the word illness. And I was trying to get at whose illness we're talking about, because that doesn't seem to be clear. And in fact, when you just say because of illness, it doesn't mean anything. I mean, you could say because of spaghetti. That's not a reason. The reason would be that there is a pandemic, that there is someone else who's ill. To just say because of illness, because illness is just a word, and it could imply illness that occurred in the past or in the future or never. It just says because of illness. Does that mean that someone who was sick with malaria in South Africa in 1825, so therefore because of illness, that illness, I would be able to vote by an absentee ballot in Connecticut in 2022. That would be a stretch, but I believe that's exactly what you're creating by not defining illness as such electors or person's illness. But the point I'm making is that you've also done this with disability. Why are we removing the word such electors or person's physical disability? How on earth would that make sense? Does that mean that anyone can obtain an absentee ballot because of physical disability? Does that mean that if a neighbor has a physical disability, that someone would be able to get an absentee ballot? Because that's precisely the argument that's being made with the word illness. Through you, Mr. Chairman.
Yes, through you, Mr. Chairman. First of all, perhaps I'm looking at a different version of the bill, but in my version of the bill, such electors or person's physical disability is still in the language of the proposal. The only place it's being removed is to qualify illness. I would also argue, that we still, with the changes to this statute, we still have some of the most restrictive language in the country to obtain an absentee ballot. There are only 2 states that ever had this in their state constitution, which makes it extremely difficult for us to make it easier for people to obtain absentee ballots, even in a situation like COVID-19. So I think to say that just by removing this qualification to the word illness to conform it to the state constitution creates some sort of open door to absentee ballots is simply not true. I wish it were, but it's not. When you say, well, does that mean somebody's illness in South Africa? How does that meet the test of not that voter not being able to get to the polls? So you're forgetting about the second part of all this, which is that person has to swear they are unable to get to the polls because of whatever they're claiming is their excuse. And so that is still the case. I wish it weren't. And I look forward to the debate on this issue next session when we can possibly get it on the ballot so that everyone in the state can vote on whether or not they'd like to have access to an absentee ballot if they so choose.
Thank you, Madam Secretary. You've been unbelievably clear about your desire for no excuse absentee voting. And again, I appreciate it, and I'm closer to you on that issue than you can imagine. But we're not discussing that. What I'm trying to illustrate here, and I'm hoping that you can help me and convince me, because you have yet to show me that this is somehow not creating a backdoor way to no excuse absentee voting. If we debate and vote on no excuse absentee voting, that's fine. But that is not what we're doing here today. Other than I believe this proposed change, it creates that as a backdoor mechanism to get there. And as I've expressed, my real concern is not even about opening up, absentee voting. It is about opening up the opportunity for ballots to be mailed to every person without the protections in place that other states that engage in that activity have. My concern here is that by redefining the statute to say that it's just illness and not a specific person's illness, you have essentially made everyone eligible, because illness is just a word, and illness has existed through time in memoriam and will into the future. And furthermore, by the language in these proposed bills does remove such electors or persons as a requirement based on physical disability, in fact, enabling you to get an absentee ballot because of someone else's physical disability. I think it makes absolutely no sense. We're obviously not going to get anywhere on that subject. We're just going to agree to disagree. But I think I would encourage people watching to read this language and come to their own conclusion about whether or not, when you take out the words such electors or persons in front of these conditions, that essentially you're allowing anyone as long as any other person meets those conditions. And I just think that that's an appropriate way to do it. I want to get back to the point of the mailing of ballots. When the ballots were mailed in 2020, Madam Secretary, how many of them were returned in the mail? Through you, Mr. Chairman.
Through you, Mr. Chair, first of all, no ballots were mailed, right? We keep getting this mixed up. They were applications for absentee ballots, right?
Yes, ballot applications, but ballots were also mailed as a result of the responses of people who requested them.
Well, ballots are always mailed to those who request them by the town clerks, not statewide, but by each town. When you send in an application for an absentee ballot, your ballot is mailed to you, right? With lots of checks and balances and separate envelopes and all those things that we talk about all the time. But just to be clear, right? So
through you, Madam Chairman, Mr. Chairman, I completely understand that, and I meant the question that I asked. I was going to ask how many ballot applications were returned also, but I did ask how many ballots were returned, because ballots were mailed to people who requested them and they were returned. And do you have that information? I know how the process works.
Oh, okay. Well, I just wanted to be clear, because you did say the mailing of ballots. And so I just wanted to be clear. Ballots were not mailed without applications. People applied for them and then they were mailed to them. I mean, I'm just clarifying that because I know there's a lot of confusion about that, because many states do just mail ballots to everyone on the list. We do not do that or anything even close to that, honestly. So your question was how many of the ballots that are mailed by the town clerks were returned to be voted. I don't think I have that information with me, but I can get it to you. Maybe Attorney Bromley, got any data on that?
Attorney Bromley, are you still with us, I believe?
Yes, I am, Mr. Chairman. Again, Ted Bromley. I don't have the exact number. We can certainly get that for you, Senator, but I do know that in 2022, generally speaking, we had about a 3 to 5% population of voters that voted by absentee ballot. And in 2020, it rose to approximately 30%. But the actual hard number, we would have to get that for you.
Thank you for that information from the both of you guys. Through you, Mr. Chairman, it seems to me that it's important information to know both how many ballot applications were returned in the mail and how many ballots were returned in the mail. Since we are in the process of doing a very significant expansion of eligibility for mail-in votes. And that's the concern here, and always has been, is the security of such an election. Can you tell me, through you, Mr. Chairman, Madam Secretary, can you tell me how many ballot applications were returned possibly in the 2020 primary or general election?
Yes, thank you. Through you, Mr. Chair. Yes, I do have that information because we were the ones that mailed the applications in 2020, both the primary and the general election. But just to make sure everyone understands, the voter file is maintained by the local registrars of voters, one Democrat, one Republican in each town. Roughly 75,000 applications that we were mailed out, and we mailed out, I think, it was probably close to 2 million, were returned by Postal Service. About 8% of those mailed out, which is, by the way, less than half of the national average of returned election mail, according to the Election Enforcement Commission. And I just think I'd take this opportunity to say it's because we have pretty accurate voter rolls. More than 150 of Connecticut's 169 towns had return rates less than half the national average. 164 towns had rates below the national average. We are leaders in maintaining accurate voter rolls. So, and that clearly has to do, has something to do why we had such a low return rate, because our rolls are pretty accurate, and it's difficult. It's a difficult job to maintain those rolls. But I think the registrars do an extremely good job of it. And of course, we've done some things to make it even better. For example, allowing you to change your address at the DMV, because, that's something people don't think to do when they move. They don't necessarily think, oh, I better call the registrar of voters and change my voting address. And so we've been able to do a really great job of making these lists much better than they have been. And I would say also rejected absentee ballots. That's always a question people ask. I'm going to foretell what you might ask me about besides the number that were returned, because this is always a question when people send in these applications and these ballots, are they doing it correctly? And we've had a lot of problems with people not understanding how to fill out their absentee ballots. It's very complicated. But I would say we are doing well on that too. And I credit that to all the information that went out during 2020. We had less than 1% of the ABs were rejected by town. We have those numbers by town, and half as many were rejected as in 2018. So again, I think we did a great job in 2020 of informing voters on how to do this. And I think it shows.
I just briefly interject here for a second. And Senator, I think I understand where you're going with the line of questioning in terms of security and the mailing of ballots and things of that nature. I just, I think the issue of the mailing of applications is not included on the bill. I'm not asking you to not ask certain questions, but I just think want to keep in mind that in the underlying two pieces of legislation before us, another one addresses the mailing of applications. So I just want to keep that in mind, and just so that we kind of keep that in the forefront of our mind. Thank you. Senator, the floor is still yours. Please continue.
Thank you, Mr. Chairman. I appreciate your concern, but we are addressing legislation that is the exact repeat of the 2020 language that was adopted that enabled the mass mailing of absentee ballot applications. And that's why these questions are coming up, because to me, that is the great concern, which is that once you make this modification, you are in a position to now mail every voter in the state who's on the voter rolls, which you can only do if they are all eligible. And the repeated arguments that this doesn't make everyone eligible are obviously erroneous, because you did it in 2020. You mailed everybody on the list because you made them all eligible by virtue of modifying the word illness. And that's what's being attempted in this statute, and the concern that I have. And I also want to just thank the chairman for his patience here. I am not trying to take a long time here. My questions, generally speaking, are quick to the point. The answers less so, and I appreciate the secretary's interest in making her points as well. And but please, I'm trying to get through this as quickly as possible. But I do have questions. Through you, Mr. Chairman, your statement was 70,000 ballot applications were returned in the 2020 primary and general combined. I have seen numbers reported upwards of 250,000 ballot applications. That's not accurate. I just want to make sure we have the proper number, because to me, that's a grave concern, partly from a cost standpoint. We're spending a lot of money to send these things out. And if our voter rolls are inaccurate enough that we're actually getting tens of thousands is concerning enough to me. But if it's hundreds of thousands, it's even more concerning. That number is accurate, 70,000. Through you, Mr. Chairman.
Through you, Mr. Chairman, the number was 75,000, and that is what has been reported to me. And it is approximately 8% of the applications mailed out. I believe it is for both the primary and the general, but I could check that. I don't know if Attorney Bromley knows if that data is just about the general or about the primary as well.
Attorney Bromley, do you wish to intervene? Interject?
Thank you, Mr. Chairman. Yes, that number, Madam Secretary, that's correct. That number is for both.
I thought so. Thank you.
I appreciate that answer, Madam Secretary, through Mr. Chairman. Although I will tell you that by my math, 8% of ballots at 75,000 would mean less than 1 million ballots were mailed, or ballot applications, pardon me. And that's just not possible. There were certainly, as you just noted, almost 2 million probably. So I don't know how those numbers do jive. But we can come back to that. And if there is further information that says that that number is not 75,000, I'd certainly like to know about it, because I believe that the citizens of Connecticut need to know that information accurately to determine whether or not this legislation is good. So what is being done through Mr. Chairman to resolve the errors that are clearly on the voter list if even 75,000 ballot applications were returned in the mail? Through you, Mr. Chairman.
Through you, Mr. Chair, as we have noted many times, all keeping of the lists is done at the local level. We do our level best to keep up with people's movement, but it is always a snapshot in time that we know that there are people who have not changed their address appropriately and so forth. So there will always be a certain number of addresses that are no longer accurate at any one time. We do update the lists every year. Every town is required to do that, and they do that audit of their list, and that's all I can say. And I think we are on record as having some of the most accurate lists certainly in the region. And we do all we can to make sure that those lists are kept up in the way they should be. But that is really done at the local level.
Through you, Mr. Chairman. So, Madam Secretary, during the primary and the general election in 2020, I received numerous correspondence from my own constituents suggesting that they did not receive a ballot application, even though they were a registered voter. I received many other individuals' correspondence telling me that they received ones for people that no longer live in their home, duplicates, because one in their married name, one in their their maiden name, for children that had moved out of state to go to college, what have you, deceased people, etc. And notably, I'm a landlord actually, so I have some tenants. And one of my tenants shared with me the fact that they received maybe half a dozen ballot applications for people that had resided at the same address over time. These are real world things. It's hard to gauge how prevalent those circumstances are. But to me, that is a concern, and why I brought up the notion of resolving the concerns with the voter list. I know that there are other folks that are on our public hearing today that are going to elaborate about their own experience with the voter lists. But I guess my question is, how do we know if we are sending out ballot applications to 1 million or 2 million people simply because their names appear on the voter list and may appear multiple times or have the wrong address or are otherwise in error? How do we know that if that person responds with a ballot application and we send them a ballot, that we are actually sending it to the right person? And furthermore, how do we know that that ballot application is being returned by the proper party? And the reason why I asked this question is because it's noteworthy that during the debate on early voting in the state Senate several years ago, Senator Martin Looney was the person who brought it to our attention on the floor by saying that he prefers early voting to no excuse absentee voting or any type of mail-in voting, because you never really know, I think was his words, who is returning that ballot. And that is my concern also. Let's provide access, but we have to make sure we provide the integrity of the election. Other states have stringent requirements for voter registration because they have large numbers of mail-in voting. As you pointed out, we have 1 or 2% typically But in 2020, when we expanded the eligibility to every voter, which was done by virtue of redefining illness and sending out the ballot applications to every person, we had a huge increase. But other states that partake in this type of mail-in voting scheme, they have signature verification process. They have barcodes. They audit the ballots that are and applications that are returned. What protections do we have in this state, Madam Secretary? And I'll add one other thing, which is that you took credit for a very low denial rate, 1 or 2%. But isn't that because we basically approved every ballot that came in, whether the signature was accurate or it was missing a signature or it was just an X? These are the things that have been reported to me, and why I'm being a pill today. I apologize. It's because I want our elections to be beyond question and above doubt. So if you could respond to what are the security protocols? Do we have a signature verification process? Do we use barcodes? Do we audit absentee ballots? Do we approve ballots that come in without signatures, without matching signatures? Through you, Mr. Chairman.
Thank you. Through you, Mr. Chairman. No, we do not use a signature verification process, mostly because we have never had the need of it. We don't use that many absentee ballots generally, but signature verification processes are notoriously unreliable. And honestly, we have looked at it in the past and decided that at this point, it would not be, it's not the right process for verification. Verification is basically done by the town clerk. They check the name against the application. And first of all, just be aware, we're not mailing ballots to people blindly. We're mailing an application. Anyone can fill out an application for anything. And so, but they have to, the first thing is they have to be on the list. And secondly, you have to sign by penalty of, it's a big penalty too. This is not a fraudulent application. So you're required to say, yes, I am the person that's being sent this application. So it's all controlled by that. And the town clerk checks you off the list, and you're taking a chance if you would do something like that the person whose name you are theoretically stealing would be not voting themselves. They would be, but what if they're voting? You would be caught immediately. So honestly, we have seen very little evidence that people are sending in fraudulent applications. The fact is, yes, there are a certain number of people that are on the list more than once. If you have moved in the last year, since the last time they canvassed their district, it's likely that you could be on the list, both in your new residence and your old residence. That doesn't mean you're going to vote in two places. There's nothing illegal about being on a list more than once. But what is illegal is voting more than once. So I think our system works quite well. We have had very little incidents of anything like that happening. And the fact is that the mailing of the applications has actually helped us clean up our lists. Because remember, when those 75,000 roughly applications came back as undeliverable, we sent them to the towns, and the towns then took them off the rolls if that was appropriate. It's just that we're very, very careful before we take someone's name off a voter roll. There's quite a long process to take someone's name off. You have to have notice of it, and you have to have not voted in several federal elections. So, and there's reasons for that. You are denying someone their right to vote the minute you take them off that voter list. So all I can say is, again, we do the best we can to keep accurate voter rolls. We are known for being one of the best states for doing that. And the checks and balances we have in place seem to have worked quite well up till now. So that's all I can say. And I do have confidence in the way we're doing things right now. I don't know if we should look at, I don't even know what you mean by auditing the absentee ballots. Would you mean like going back to try to find out if every person is who they say they are? How would you even do that? I'm not sure. There's been a lot of talk about audit processes lately. And you just have to remember the fundamental law is that we have anonymity. We have private ballots. So you're never going to be able to go back and find out who cast that ballot, hopefully, because you have a right to have privacy with who you voted for.
Thank you for that answer, Madam Secretary. And through you, Mr. Chairman, thank you for that lengthy answer, actually. But let the record show that when I asked, if we have any actual security, the only thing that you brought to my attention was that we are careful, allegedly, about our voter list. And I think we've already illustrated that we're not particularly careful about our voter list. Someone also pointed out to me that 8% of 2.4 million voters is 184,000, and that the statistics that are out there reflect 184,000 returned undeliverable in the general and 100,000 in the primary, for a total of 284,000. If the number is actually 75,000, I apologize, but I have no reason to believe that these other numbers are inaccurate, since you pointed out 8% yourself. You also noted that why would we audit? Because we'll never know who actually sent that ballot in. I think you were making my point, Madam Secretary, that that's the concern with a very fast expansion of mail-in voting, is it's never going to be as accurate as in-person voting, where you can identify the voter. I just think I'm going to wrap it up right now, Mr. Chairman, just because I know a lot of people are patiently waiting, and I am very sorry for how long this took. But I have one final question, which is, through you, Mr. Chairman, Madam Secretary, what would you describe as the difference between the election in 2020, November 2020, and if there was a no excuse absentee voting election? And please answer me, respecting the fact that you decided that every person should get a ballot application in the mail simply for being on the voter rolls, which would imply that they were all eligible. And in fact, your insert on those ballot applications indicated that every person could, in fact, check off the box for COVID. That implies that that was a no excuse absentee voting election, and that you could, in fact, vote because of COVID, not even because you had COVID, or not because fear of COVID, and not because your neighbor had COVID, but because of COVID. And the fact is that 1,000 years from now, because of COVID will still apply, because it doesn't say who it actually has to be ill. And I know I'm getting into the weeds here, but I'm trying to find out in your mind how you separate that election from an actual no excuse absentee election, since everyone at the time, including the governor of the state, referred to it as a no excuse absentee vote election. Through you, Mr. Chairman.
Through you, Mr. Chairman, I can only repeat what I've said many times. The reason we all took those actions in 2020 was because we never wanted anyone to have to make a choice between their health and their vote. I still believe that is true. And I think that is, to a great degree, the reason we're doing what we're doing today and offering this amendment to the statute. And that's all I can say. I think it was the right thing to do. I still think it's the right thing to do. And I think these decisions should be left in the hands of the voters. Let people vote. That's all we want to do. We want to make sure everyone can exercise that right to vote. And that's how we chose to do it. And I still stand by it. I think it was the right thing to do.
Yep. Thank you very much, Madam Secretary, for your answers today. And I appreciate that answer also. And again, I agree with you. I want everyone to have access to voting and have the right to vote. But it does require a change in our state constitution to allow people to vote by absentee ballot outside of the reasons that were suggested. You did that in 2020 without a change to the Constitution. And this proposal before us, I believe, attempts to do the same thing, since the same exact language. I think it is clearly unconstitutional. I'm more than happy to have the debate about modifying the Constitution, but that is what would be required. And I will just leave it right there for now, Mr. Chairman, because I want people to understand what we're truly debating here. It should not be an argument about how one person wants the widest access of voting and someone else does not, because we all want the widest access of voting. But we have a constitution, we have a process, and we should also be concerned about the integrity. And with that, thank you very much for your indulgence today, Madam Secretary, and your patience with me. And thank you, Mr. Chairman, for allowing me the time.